I got it.
Yeah. Good morning, everybody, and welcome to MacroPro and Friends. We are doing a special edition of MacroPro and Friends. This is our first ever webinar, something I'm sure that we will continue to add to our portfolio of educational opportunities for our clients. Today, we are going to be speaking on the coronavirus and the effects that it is having on all of us in the claims industry. So this presentation is worth 1 hour of CEU credits. A certificate will be emailed to you within 36 hours of this presentation. If you don't get yours, please let me know, and we will make sure that we send you a copy for your records. In addition, we wanted to let you know that we have panelists that are going to be joining us today. We have 4 panelists, and our panelists includes, wait a minute, this is the wrong slide. Yeah, no, okay, sorry. Our panelists include Chad Coleman, managing partner of Coleman Chavez and Associates, Aston Wolfton, owner of Tuco Med, Chris Champlin from C&W Claim Solutions, and of course myself, Diane, with MacroPro. In addition to that, we were going to have Wendy from MacroPro come in, and she'll be asking some of the questions that you guys are asking. So there is a chat button, and you are welcome to ask questions. Wendy is going to go through the questions, and as the speakers have opportunity, we will go ahead and answer those questions. So let's go to it. The first thing we're going to talk about today, and we're going to speak with Chad Coleman, is about what's happening in the arena of the courts, what's happening with layoffs, analysis, and any legislative changes. Chad, so let me start with you. Let me ask you, do the injured workers get TD benefits if they are laid off or downsized because of this, because of the coronavirus and the reduction of workplace?
Oh, thanks, Diane. I appreciate being here. This was the first question I started getting when employers started looking at their workforce for reduction in force and layoffs. They started worrying about, what do I do with my current claimants that are out on disability or that are back in the workforce but doing modified work? When I let everybody go, does that mean I have to start writing them a temporary disability check? And when I started practice way back in the 19s, we were taught that temporary disability is by definition a wage replacement benefit. So conceptually, you're looking at temporary disability as replacing what would otherwise be a wage the claimant would receive. And in this situation, when everyone's going to be laid off, your injured workers would not ordinarily be getting a wage just like their coworkers. But they're a little different insofar as they are industrially disabled. So while I went into the research project thinking I was going to find support for there being no entitlement to temporary disability, what I found was actually to the contrary. If an injured worker has returned to their usual and customary work, whether they're permanent stationary or not, they've come back to doing the job they were doing at the time of injury, law tells us that they're not entitled to temporary disability at that point. Additionally, if they're MMI, but their claim is still open, they're not entitled to temporary disability. So if there's a reduction in force in that situation, layoffs, there is no entitlement to temporary disability, regardless of the fact there's an open comp claim. That's the easy question. The harder question is when you have an injured worker who has work restrictions flowing from their industrial disability. If an injured worker has work restrictions of any kind, even if those work restrictions are being accommodated, then they have a disability in the labor market. And can qualify for temporary disability. The cases that talk about other reasons people are not working say, hey, if any portion of the reason this claimant is not working at their job has to do with their industrial disability, then they qualify for temporary disability. Now, there's a bunch of other questions and categories where we looked at where temporary disability may be denied. We couldn't find direct authority on point. We've never had a pandemic like this that caused closing of industries and businesses throughout the state. So we don't have anything to fall back on directly. So we start looking at analogies and other situations where people may not work and whether they're entitled to temporary disability during those times. One of the reasons, or one of the things we look at, is the intent of the employee. In your retirement cases, you have an expressed intent of an employee not to come back to work. At a certain point, they've declared, at that point forward, I'm not going to be in the labor market. So even if they are disabled from their industrial injury beyond that point, their statement that they're not going to be in the labor market, that they've retired from the labor market, is enough to deny them temporary disability. They've expressed in advance that there is no wage to be replaced. And you focus in on the intent of the employee, the expressed or provable intent of the employee. We're a little different. We don't have, in this situation, the facts that you're going to have in your cases are unlikely that you have the employee saying they're not going to work. The intervening agent that's keeping them from work is the virus and the employer's decision to stop everyone from working. So the intent of the employee to not work just is not there. So the retirement cases, as analogies, are probably not going to hold water. So the next category we looked at were employee disqualification cases, your termination for cause cases, your illegality cases, things like that. These cases are other situations that injured workers would be entitled to temporary disability, but for some intervening event. In these cases, the intervening events are controllable or actions done by the injured worker. You have either malfeasance done at work that led to progressive discipline and termination for cause, or some legal reason why the employee cannot be returned to work. Comparing that to our situation, it doesn't seem to apply either. We don't have any act by the employee as an individual that's going to disqualify them from benefits. And so what are we left with? We looked at cases that we could find where an individual business had gone out of business. And in those situations, while it wasn't industry related, it wasn't systemic, it wasn't societal, it was focused on an individual business. In those instances, the injured worker was able to collect temporary disability. You didn't just cut off temporary disability because the company went out of business. They had to continue to provide benefits. So going through the torturous and rigorous examination of all the cases, it looks like temporary disability is likely to be due in these situations. And in talking with my clients in the last couple of weeks on this issue, most have made the determination to continue benefits. I would never tell a client they can't have a trial, so certainly you could take the position that it's a wage replacement benefit and that temporary disability is not due. I just don't think it's going to be supported. Certainly from a public policy standpoint, you're not going to have a lot of momentum behind you taking that issue to trial. And from looking at all the cases that seem to touch on the fringes of the issue, it doesn't appear to be supported.
Got it. So I see, Chad, we're going to talk a little bit now about analysis. So how is it that COVID-19 might be determined as compensable in the workers' comp industry? Is there analysis for that to show it is?
There is, and the analysis is actually pretty simple. We all know how to do it. We've been doing it for years, for as long as we've been in this practice. You initially start off determining, is what we're dealing with an occupational disease or a non-occupational disease? An occupational disease is one that naturally flows from the workplace. If you are working with a chemical and that chemical has this side effect and you develop that side effect, then you've procured a naturally occupational disease. Non-occupational diseases are different. They're things that can be contracted in the workplace, at the grocery store, at home. They can be contracted anywhere in society. And the allegation is that they've been contracted at the workplace and therefore they should be compensable for some reason. And once you've determined that COVID-19 is a non-occupational disease, we move on to what is the general rule with non-occupational diseases. And in those cases, the general rule says they're not compensable. The policy being that we don't have specific proof that it could have been contracted at work, it could have been contracted anywhere, and you need some particular element of work before you can call it a compensable industrial injury. Like every rule we have in workers' compensation, there are exceptions to it. where courts have found the need to deliver benefits. Non-occupational diseases are no exception. The exceptions that we look at are, one, is there a scientific link to the industrial injury? And that's talking about situations, for example, someone in a lab dealing with COVID-19 has an open wound or a needle prick or something like that, and they contract the disease. There's some sort of scientific link to this particular disease and exposure that was incurred at work. The other exception, which is the most common one and the one we're going to be dealing with 99% of the time, is did the work the injured worker was doing create a special or heightened exposure? And if so, if there was some special or heightened exposure created in those situations, we're going to find an industrial injury. So once you get to where you can make the industrial injury, the analysis is pretty simple. It's the same AOE-COE analysis we've been dealing with for years. It's a factual analysis, and you're going to absorb and put forth as many facts as you can. But there's no special labor code section or regulation that deals with compensability and non-occupational diseases. The AOE-C analysis is really keyed upon the burden of proof. If in the regular case, the injured worker bears the burden of proving AOE-COE, they have to put forth factual evidence, medical evidence to support their injury. They don't have to show that they've contracted the injury on a medical certainty at the workplace. They just have to show that it was a medical probability that they contracted it through work. And you're going to be looking at facts. I'd love to be able to give the audience a bright line rule that explains or analysis that explains how you're going to analyze these issues factually. But the facts and circumstances are going to be different in every case. The more facts that you have to support the injured worker being out in the community, being functional in the community, the less likely it's going to be industrial. This is kind of a unique disease. There's cases, and the handout that everybody has lists a bunch of cases that talk about non-occupational diseases. I'll touch on it briefly. But we're dealing with a situation, when we look back at all the case law, all the non-occupational diseases did not involve a mass quarantine, which really is going to affect the factual analysis. The mass quarantine says all of this societal exposure that is involved in this factual analysis needs to go away. And by law, we're going to do away with this societal exposure, which leaves you with work exposure if you're an essential employee, or non-work exposure. So it should be a little bit, it's probably going to be a little bit more definitive than it's been in the past. You're going to be looking at, is this an essential employee? Were they working through this crisis? You're going to be looking at timing. We've learned with this disease, we have a 14-day window of exposure and symptoms manifesting and those types of things, a limited window to where we can assess when exposure likely occurred. And was there work during that time, or were they quarantined? But the case law that we have looks at a variety of things. The Johnson case is a polio case from 1958, where polio was found non-compensable for various circumstances. We have valley fever cases. We have silicosis cases. We have a couple influenza cases in the record. One finding the influenza industrial. This was a healthcare worker working at the time of an epidemic in San Francisco. He was a hospital steward. In that situation where he was actively working with during an influenza epidemic, they found the condition compensable. The other was a school teacher who was also working during influenza issues, and that case was found non-compensable. So the cases are going to be keyed on their facts. And that's really what it all comes down to. If you have the burden of proof and you can put forth enough facts to show that you were special, that you had heightened or special exposure, then the condition is going to be compensable.
So, Chad, are you saying that it is the employee's responsibility to prove they have the burden of proof, or is it the employers who have the burden of proof?
The burden of proof in an AOE-COE analysis, burden of proving injury is with the injured worker. That's the current state of the law.
So let me ask you, do you see any legislative changes on the compensability of these type of cases that may be coming up in the courts?
Well, we probably won't see them in the courts. We'll probably see them through the legislature or through the governor issuing an order to some particular effect. But I went online again this morning to double check, and neither the Senate nor the Assembly has any pending legislation that's going to affect workers' comp as to COVID-19. There was a report last week that Governor Newsom has already been approached by the police officers, the National Police Officers Union, to come up with a statutory fix or a declaration to address this issue. And what we would anticipate is what we've seen in the past with other conditions that are hard to prove. We've seen union-based operations, union-based employees use their union lobbying groups to influence the legislature to bring forth legislation that affects the burden of proof. Instead of having the injured worker proving that they suffered injury, there is a statutory presumption in many instances where once they demonstrate that they've had any exposure, the burden shifts to the defendant to prove that that exposure or that the injury itself did not flow from their work. We see that in cases of cancer, heart injury, heart disease, MRSA, and some other bloodborne conditions that are tough to prove. And what we've seen historically in California is that the unions representing your first responders, your police officers, firemen, people like that, get to the legislature, they impact the burden of proof by getting these presumptions passed. And these conditions that are very difficult to prove arose from work become assumed or presumed that they arise from work. Now, the union, as I mentioned earlier, the union in California, or the union representing the National Order of Police, has already approached the governor. I would assume the other unions and their lobbyists will be approaching legislators to bring that legislation. In other states, we've seen it happen already. Up in Alaska, they passed a bill. It was sitting in the governor's desk, on the governor's desk the last time I checked in. Minnesota tried to pass a bill, but that one failed. So we're going to see some regulatory changes. We've also seen some cases, some reporting out of other jurisdictions about the claims themselves that are being filed. In Washington, where they had one of the first outbreaks of the virus, we got reporting last week from them that they'd already seen over 250 COVID-19 industrial claims, 216 of that coming from first responders. So as we assume, most of your first responders are your primary claimants in these cases. They're your essential workers. They're the ones working closest with the disease. And Washington reported that they had already addressed and closed 96 of those cases. So 40% of those cases had already been closed. And in the cases they closed, only 4 of those had been determined positive tests where the claimant had already worked through the virus and recovered completely. So a lot of fear and a lot of filings because of the fear. And at least so far in the preliminary reporting we've seen in Washington, it hasn't proven to be actual exposure that creates a lot of liability. But you know, I was also asked, who are we going to see making these claims? As I mentioned a minute ago, police, fire. I've been approached by hospital groups, by pharmacy groups, and other essential businesses to say, hey, do you see anything coming down as far as legislation that's going to affect our liability going forward? And in California, all we can say is historically, these issues are matters that are pushed by unions. And so we will likely see the police and fire aspect. We may even see government-run health facilities like your University of California hospitals or other government-run facilities, upstart medical facilities that the government's put forward. We may see presumption statutes passed that affect them as well. But that's where we would assume it's going to come from first.
Okay, thank you so much for that. We have Wendy that is going to be joining us, and Wendy has got, she's going to ask one of the questions from one of our viewers today. So what do we have for Chad, Wendy?
Chad, we have a question. Can you briefly touch on safety employees like police and firefighters being exposed due to the nature of their job? So I know you just talked about it a little bit, but can you expand a little bit on that, please?
Yeah, I mean, that's where we're going to assume that most of your claims are going to come from. because they are out there on the front lines. They are the ones that are actually and actively interacting with the public. They're not alone, but they're the primary people we see interacting with the unhealthy public. I had a story here in Rockland. We had one of the first COVID-19 deaths in the state, and the police department was called upon to go and isolate this individual. They've been briefed by the CDC and all these things, and until the governor passed his order, they didn't have any legal authority to direct the public to do anything. Because of our various rights in our country, they didn't have a lot of authority to do much. Well, they now do, and they are actively doing so. They're actively interacting with people that are reporting problems breathing. The fire department's showing up, ambulances are showing up. They're taking people to the hospital. They're monitoring people that have been ill and are quarantining, those types of things, especially in your smaller jurisdictions where the number of people are limited. So they are going to be the people we see first, and the data we got from Washington is probably the best support for that. 40% of the claims, or excuse me, I think it was 80% of the claims, over 80% of the claims that had been filed in Washington claiming injury from COVID-19 were from first responders. And we would expect to see the same thing here in California.
So the next question is, what if the safety officer is off work due to the 14-day quarantine and then the test results come back? Do we pay for the indemnity benefits while they're on quarantine? And is there no real medical treatment, if there's no real medical treatment being provided if they're just on quarantine?
Yeah, I think the answer is yes, so far as there is a claim reported. We don't have a lot of guidance for this, so we're just kind of speculating at this point. If someone is directed to go home and they don't have the medical condition that would qualify them for comp benefits, then they're not going to get comp benefits. That doesn't mean they're not entitled to other benefits. There are rules in place where medical treatment gets paid for before claims are denied, but the rules don't apply to temporary permanent disability. So we're going to work these through just like we would work a normal case until there's some sort of legislation that comes out and directs otherwise. So in that situation, if I have the facts straight, the facts don't support that there is a COVID-19. It's more of a stay-in-place protective thing. In that situation, ultimately, if the claim was not accepted at the beginning and it was delayed or denied, benefits would not ultimately be due. But that doesn't mean we're not going to see something different come from the legislature that affects that analysis and puts the burden on the defendant. Our comp bills tend to trail because they're not emergency in nature. So the benefit bills that involve COVID-19 that I looked at today appear to be more on an emergency basis. So I would expect to see something out of Sacramento probably in the next couple months.
Thank you, Wendy, so much for asking the questions of our viewers. We'll see you in just a little bit. Chad, thank you so much for your input on the law and what's going on. Just real quick, is there anything about the courts and what's going on with the courts, or are they completely dark? What is it that the examiners can have the attorneys do at this point, and what is it the law firms are able to do?
Yeah, the courts are open. They're not open to the public. They're not open to walk in. Those doors are still closed. They're re-examining that here in a week or so to see when they think they're going to open the doors. What we're working with now is expedited hearings, issues of medical treatment and temporary disability are going forward. Expedited trials are going forward in person at the boards. So you can still have an expedited hearing, but other hearings, status conferences, AOE, COE conferences, MSCs, they are not. They're going forward on we were using court call just this week. The state was able to get conference line numbers, so we're no longer having to incur court call fees, but we're doing our status conferences and MSCs over the telephone and appearing that way. We are still able to get settlements approved. Settlements are not being approved on a walk-through personal appearance basis, but if we're able to get those to the courts electronically, which most law firms are, the judges who are working at home and having less appearance time are not only instructed, but are also actually looking at these settlements pretty quickly. We're seeing 2, 3, 4-day turnaround on electronic submission of settlements and them getting addressed. Because the judges have more time, they're not spending 3 hours in the morning and 3 hours in the evening in their hearing rooms. They're at home unless they have an expedited hearing. So they have more time to look at these things, and they're getting back to them pretty quick. So we're getting settlements done. We're getting hearings done. Trials and expedited trials are going forward, and the business of comp adjudication, while operating differently, is still operating.
Great. Well, thank you so much. We're going to, Chad, if you'd stay on, because we're going to wrap up and get some final words from you at the end.
Sure.
We're going to switch a little gears, and we're going to talk to Ashton Wolfson and talk about what's happening with AME and QME. So Ashton, can you tell us what the DIR is saying about the QME and AME process at this time?
Well, hi, Diane. Thank you for having me on. On March 28th, the DWC issued some emergency measures for med legal evaluations during the stay-at-home order. Some of the things that had come up were regarding telehealth, but some of the other things were regarding appointments. The DWC is encouraging right now all parties to evaluate whether to continue with the cases, whether to cancel or postpone, or they're just basically asking us to have all the parties figure out whether to proceed with cases right now. So they're basically putting it on all of us to decide whether to continue or put everything on hold.
Okay.
With that said, I'm sorry?
No, go ahead.
With that said, are we setting appointments? Based on the guidelines that the DWC provided, my group, we are still scheduling appointments because at some point this is the stay-at-home order is going to be lifted and life goes on, and we're going to have to continue and try and get all these cases evaluated. So as of now, we are still taking cases, but there are other doctors who, because maybe their offices are closed, their staff can't work remotely, they aren't scheduling anything right now. So a lot of it is on a case-by-case basis. So that's kind of what we're looking at this moment in time. With regards to safeguards, I can't speak for all medical providers, but one of the things that we've implemented is that we are actively phone screening all applicants during this time. And it's probably going to be a process that's going to continue towards the future. Because even though the stay-at-home order may lift, hopefully sooner rather than later, Corona is going to continue to be a problem, and safety is going to be paramount for all parties, the injured worker, the staff, and the doctors. So during this time, we've been screening appointments. We've been asking them, well, have you been sick? Have you been around anybody who's sick? Have you traveled? And we've noticed that the applicants appreciate that, and we've had, as a matter of fact, many cases where we had doctors going out, and some of the cases opted to stay home because they hadn't been feeling well or they were around people that hadn't been feeling well. So in that regard, things are working. That seems to be working fine. I just off the top of my head, I was thinking last week we had a case where an applicant, we were screening him, and they said, well, my child was really sick and I'm not really comfortable with coming in. We said, fine, we'll try and we'll reschedule you and try and get you on for another occasion. So that really worked. We've also found, yeah.
Can I ask a question real quick?
Sure.
Are you guys doing video appointments? Is that something that is going to be available?
Yes. You know, as far as video appointments go, it's something that we have discussed, I know there's been a lot of talk about it within the site community because they tend to have longer face-to-face times and less physical interaction with applicants. I thought, to be honest with you, I thought telemedicine would be a very exciting thing to implement, but on the surface, it seemed very exciting. But once we got into the actual process of it, it seemed was a little complicated. You know, my group specializes in orthopedics, so as you can imagine, doctors need to be able to examine applicants. They need to check range of motion. They need to be able to see if the patient is wincing. They need to take measurements. So that becomes a little problematic when you're doing a telemedicine type operation. The tasks, you know, those are difficult tasks to do on a video call. Also, once we got into really evaluating, there were a lot of pitfalls associated with telemedicine. We need to be able, things like, we need to be able to see if the applicant has access to a computer or is tech savvy to be able to work an application like that. How do you loop in an interpreter? A lot of our physicians are of a grayer demographic and aren't as apt at using technology, and they're very used to having their processes in place, and to stick them on a telemedicine type situation to examine an applicant could become very problematic. Also, the biggest thing, how do you bill for face-to-face when you're really not face-to-face with them? That can present some issues down the road, especially with the DWC.
Interesting. Is there anything else that you would like to have our viewers know? I know we have a question, but I want to give you an opportunity to share any other information before we get to the question.
I know there was a thought out there. What do all the doctors think of this? And you know, within our group, all of our doctors, they're people, and some of them have a higher tolerance for risks than others. We have some that are really, they're more than willing to go out and do evaluations during this current time if we implement safety protocols and continue screening. We have other doctors that have opted that they don't want to be out during this time and they're willing to do it later. So as a result of that, we're going to see situations right now where it's going to take longer to get these examinations done because there are people that will be opting not to go in for their examinations. There are going to be doctors unwilling or not wanting to do the examinations. So it's going to take a little longer, but at the end of the day, we'll get it done.
Great. Hey, Wendy. Wendy's going to join us here, and she has a question for Ashton. What's the question, Wendy?
Actually, the question was for Chad. Sorry, Ashton.
Okay. That's okay.
Can I ask the question to Chad, Diane?
Certainly.
Okay, Chad. With medical appointments being canceled or pushed out to later dates, do you think we can push for settlements without MMI and using estimated PD ratings? Would the WCJs be more amenable to that? MMI and using estimated PD ratings, would WCJs be more amenable to that?
Well, we're going to talk about that at the end of the presentation, so I'll hold the answer till then, but it's the exact topic we're going to touch on when we close.
Fantastic. Thank you.
Fantastic. Well, Ashton, thank you so much for the information, and stay tuned, stick around as we're going to get some closing thoughts from you too. We're going to switch gears now. We're going to talk a little bit about the importance of early investigations using social media and what is going on as far as investigations are concerned. So we have Chris Champlin on the phone. Champlin, sorry about that. How long have I known you? For a long time. So Chris, can you tell us what you're hearing as far as nationwide claims? I know that you have your finger in the pulse of that. You have quite a few clients that are nationwide. And so what are you hearing from them and from some of your colleagues in the industry?
Yeah, thanks, Diane, and thank you for putting this all together for us. I think, as you can see, this is a learning process. Kind of going back to Ashton's. Let's see, I'm pointing in the wrong direction. Going back to Ashton's point, this video chat, video interaction can be a little cumbersome. I understand some people are having some difficulty. So, thank you, Diane, and Wendy, and everybody at MacroPro for putting this together. Yes, so we handle a great deal of national accounts, and obviously, and I think everybody here in the industry has noticed, claims are down um, across the board. I talked to some folks at Gallagher Bassett the other day that they had a meeting, and I've been on the phone with some of our larger accounts that they've been conducting furloughs, RIFs, letting people off, so they don't have the people there. We just received a word the other day that one of our insureds has 30 confirmed COVID-19 claims. Currently, some of our accounts are treating them as you would any other bloodborne pathogen exposure type claim, and they're going to have us start working on a special project for them. We're still putting that in the works right now, so things are obviously progressing. But going back to something Chad had mentioned, and Wendy, I don't know if you saw my question to Chad, but I'll bring it up now because I think now more than ever, it's important to ask a little bit more questions when it comes to your initial 3-point contact to determine AOE, especially if it is a COVID-19 type claim. I'm sure you all have your own protocols right now. But Chad did mention that AOE COE exposure is critical to determine the how they came down with this disease. So Chad, I can think of a few questions off the top of my head before during their initial 90 days while they're still processing the claim. Things like are family members exposed or have been exposed? Have they been out? Shopping, or tell me about when you're not at work, what are you doing? If your entire family's on lockdown, could they have come in contact where you would have come in contact? So these are going to be some new questions that you're going to need to add to your arsenal during your initial 3-point contacts. But Chad, can you think of any other specific questions that would help them with the AOE COE aspect as they're doing their initial phone calls?
Well, I mean, the feedbacks are going to be huge. I don't know about specific questions. It's more going to be in the details and the follow-up. You're going to need to touch on when they first went off work, what they were doing before they went off work, what they were doing while they were off work, the things that we know we're all doing. We know we're all still eating. Are we going out to pick up food? Are we having it delivered? Are we doing both? Some of my neighbors like to have driveway parties where they all throw out lawn chairs 10, 15 feet apart, and the kids are still playing basketball together in the street. Well, that's interaction, whether they understand it or not. But getting as much of those details, the more volume we have of those details, the easier it's going to be for a judge to sort out whether there was a special or a heightened risk at work, or whether this was just the general risk that we saw in the cases historically.
Well, that is perfect timing for the next question for Chris. So Chris, can you tell us how social media, early investigations using social media can help the claims examiner with COVID-19 cases in the future?
Yeah, I was gonna go there. That Chad just hit on a bunch of good points, and things that can be supported through social media investigations. One of the things to think about right now, a lot of your PI companies are not doing as much surveillance as they used to. They, as Ashton said, we're all human. They don't want to put their employees at risk by going out there. I've spoken to several of my colleagues in the industry. Work has slowed down for them a great deal because a couple of things. One, employers are watching their bottom line right now. They're not willing to want to spend the money if, what are you going to prove on a COVID-19 claim with surveillance? If you still have your orthopedic type claims, you still have your any of your other site claims. I could see site claims might become a big topic right now. People are worried and scared. But social media is going to key in on all of the questions that you've been asking. If you say, hey, have you been doing your social distancing cocktail parties? Oh, no, we don't do that. Yet you find out on Facebook that they're bragging about, hanging out with their neighbors, going on walks or hikes or things like that. That'll help. That is definitely going to help. Everything else that goes into a background investigation right now, first of all, it's a lot less expensive than, say, a surveillance case would be. So there's a financial aspect there that's gonna help a great deal. It's also gonna help you put together what questions you should be asking, because if you know they're doing these things, if you know they're out there still interacting, I see we just moved to the next slide, so I guess that's where I'm going with this thing.
Keep going. I see it ties into the third question that we're going to.
Yeah. These things are still going to help you make fact-based decisions. It's still going to help you support your recommendation for surveillance. We just did a case the other day. The gentleman is a gym rat. I don't know if Sarah Fain is on the call. It was one of her cases. This guy actively went to the gym up until, it's an orthopedic claim, by the way, actively was going to the gym and now is filing a low back injury. But he can't go to the gym anymore because the gym's closed. So would surveillance help? Well, as a matter of fact, he is posting his activities on social media. He's still going for a walk. He's still talking about exercising. He's still doing all the things that he's probably claiming he can't do. So in that instance, with the background investigation, with social media, now she can support her recommendation to her to the employer that, hey, we know he's doing these things, we should send somebody out. So it's kind of like a screening process with the background. Do the names match? Do the records match? Are they working outside? Maybe they say they can't come back to work for you because they feel they've been exposed, but maybe they've got a side job somewhere and they're still active doing that. These are the kinds of things that are going to help you right now strategize, plan, acts. Listen to me. I'm working from home and I already can't speak. Ask the right questions, to put an action plan together, and then you can sell that to your employer if you need authorization. One of the things right now, and we haven't seen it yet, but again, I've been speaking to some of our vendors that provide us with data, and nationwide, they are suspecting some fraud as part of this. People are going to start faking a COVID-19 exposure so they can get out of work. Now, I don't know what benefit that would be for them as this thing is still progressing, but keep your eye on the ball on that one, because more and more people, I almost think it's like yelling fire in a crowded movie theater. I mean, my wife, bless her heart, right now is still working. My wife's considered an essential employee. She is in the aircraft maintenance area here in Northern California. She has 48 employees still working at her facility. They do an extensive screening process for COVID-19 at the front door before her employees come to work. Questionnaire, they have to do the temperature thing. But I asked her the other night, I said, so what happens if somebody pops positive for COVID-19, or at least is symptomatic and claims they are? She goes, well, we got to shut down the site. We got to scrub all the equipment. We got to shut down that work area. And that's a big financial loss to our employers for bogus claims of COVID-19. And again, social media, like Chad said, if you can get any evidence to support that, maybe they're talking trash about their employer on social media, that's going to help with your claim. And again, as I turn this over to Diane, I think a lot of you have heard me speak at the MacroPro and Friends events before, but multiple aliases, multiple names, anything that's going to help you get the records you need right now, on non-COVID-19 cases, is definitely going to help you mitigate your risks and claims. Finally, I know a few of my colleagues are on the call right now because I think everybody's trying to learn more about what's going on in our industry. And like Ashton, I can't speak for everybody, but I do know about 3 companies right now that are slow. You know, they're still willing to go out and do things, but that they have slowed down. Again, AOE COEs can be done just like this. It's a little easier than, say, a QME orthopedic examination. But if you do need a full interview, it can be done over the phone. It could be done via video. I know private firms that have started this technology that are still out there. The problem with that is, you know, you can't have them sign any HIPAA release forms or anything like that. But, you know, we had a saying in the Marines: improvise, overcome, adapt. You know, that's what this could be the new normal for now. You know, and
maybe they can email sign back.
Pardon me?
I said perhaps they can get their authorization forms emailed over, have them scan it back or take a picture of it and send it back for that reason.
Yeah, there are a lot of options out there, and again, technology could be or could not be your friend right now. I mean, that's kind of what we're dealing with. I mean, for today's program, I couldn't even get a webcam. I'm using my laptop now because webcams are sold out everywhere, and Amazon wants a boatload of money for us to get a webcam, and I go, I'll just use the laptop.
Hey, Chris.
Yeah.
Chris, I see that Wendy's here. She has a question for you. So Wendy, what's your question for Chris?
The question was asked, will there be problems with the stay-at-home order if an investigator is out doing surveillance when they're not supposed to be outside unless they're going to get food or to the doctor? So does that apply for you, and can you still do surveillance if you're being asked? And then the second question, I'm just going to ask them all so you can get them all answered. What exactly are you looking for on social media? What about using a neighbor's home gym, or do you take into consideration photos of a finished project in the yard, the garage, or even in the house? Maybe somebody painted the kitchen counters. And then there's one last question.
I don't know if we can answer them all.
I'll be quick.
I think that maybe they can, yeah, go ahead.
No, what was the third one? And I can tie them all in.
And then can the investigator be ticketed for doing surveillance during this time? And if you're ticketed, does that come out of your pocket or does it come out of the claim?
All right, some of that I can answer, some of that I can't. As far as I think the first question was, should a PI be out there doing surveillance during a lockdown? They are doing it. I would consider it essential. I don't think there's been any arguments to that. You know, one of the things as a law enforcement officer, I learned a long time ago, letter of the law versus spirit of the law. If they can prove, just like any other surveillance case where we go out to do surveillance, that they're there investigating a claim, you know, or they call into that agency to let them know they're investigating the claim, they'll probably be left alone. Now, I haven't heard of any instances yet. Maybe there have been a few businesses that have been cited for operating, but I don't think in California we have to worry about getting a citation or pulled over for being out in public yet. I don't think, unless anyone else has heard different. What activities a surveillance investigator would be looking for, or what we would be pulling off of social media, really it depends on the profile. If it's open to the public, I mean, we look at everything: Twitter, MySpace, Facebook. I mean, there are hundreds of social media sites out there. People still advertising on Yelp about, hey, we're still open. You know, I'm looking for a mobile pet groomer right now, my dogs. Having a hard time. If anyone knows anybody, let me know. Call me. There's a lot that goes into the social media aspect, and we don't know what we're looking for until we see it. And then you asking the right question is going to help. If we get a picture of them working out or bragging about their home gym, now you know to ask, are you still working out even though you're locked down? Oh no, I can't. I'm following. Well, BS. We call BS on you. Now you send a surveillance guy out there and you catch them with their garage door open working out. I hope that answered your questions. If you don't, if you have more, just call. I mean, we're running out of time here. I know Diane wants to talk. So just call, email, any of us, really. We're here to help. I mean, look, I'm here at home right now. Call me.
Thank you, Wendy. We're going to go ahead and we're going to talk a little bit about your records and what you can expect. So we were very lucky here at MacroPro. We had a pandemic plan in place and we were able to execute it very quickly. So we were able to get our employees working from home. We still have some employees that are working in the office. We're practicing social distancing, doing all the cleaning, everything else that other essential businesses are doing. But because we already had a plan, we were able to make sure that we limited the downtime for our clients. So there's a few things people and clients have been asking, and would be true for all, I would assume, all copy companies. The question is, can we still order records? Absolutely, you can order records. There are people that are working to be able to facilitate the record order process. But here's what you do need to know about getting records. The question is, what you should know about the custodians. So the custodians, when this first started, prior to becoming a pandemic, they were allowing foreign, I should say, non-employees into their offices. They were screening them for favors, for costs. They're doing observations. Once they cleared the observation period, they would be allowed to come in and do their scanning of records. The minute it became a pandemic, very smartly and best practices, they shut down their facilities to anybody other than their employees that were considered essential. Now, what we have to envision is this. We're still getting records and we're still processing orders, but we are not going to be able to get those records as quickly as we have in the past. Let's say there are, for argument's sake, 250 copy services in California. Of course, there's way more than that. And each of them set appointments with all of the different facilities. And if you could imagine a line of people standing at a door waiting to get in, the custodians, usually one, maybe two people in each facility, now have to do the work of all of those companies that are standing in line because they are no longer able to have the service come in and process these orders on your behalf. This now means it's more like the 405 freeway down in Southern California, where there's a lot of gridlock and it's very, very slow. So we just have to keep in mind that things are not business as usual when it comes to getting records from your copy services. The other thing is, let's talk about the best way to order records. The best way for you to order records is online. And the reason I say that is, when you key in the information, you provide everything to your document retrieval company, it's in the system. And they can, from that point, and we can from this point, we can start serving our authorizations and our subpoenas. We are serving by mail. We cannot serve in person any longer. And we believe this is best practices. Now, whether or not every facility is going to accept that, we don't know. But we feel that in order for us to do the best job possible for our clients, is we have to get you in queue to get your records. Because now, like I said, we have this big long line and we want to make sure that you're in queue. Because we have employees working from home and limited employees in the office, we and other copy services obviously don't have the manpower to do what we used to do in the past. You used to be able to send an email, somebody would take that email, put the information in the system, get it ready to be served, and prepped and served. It can be done, but it could be days and days before that can happen, depending on the volume. And I'm here to share with you that the volume for records is gigantic at this moment because people have an opportunity now to request records. So if you can at all key it into the system, that is the best way to do it because there's no shortage in requests for records. Our customer service team is here to help you, but again, we are short-staffed. And I think if you are working with a company, please give those people a little bit of time to get back to you. Your typical fast service isn't going to be happening. You're probably going to wait a day or two for a return phone call and a return email because things just aren't the way they have been in the past. You have a question, used to be the customer service rep could then look at the question, go have the file pulled, look at everything that's going on. Now everything has to be done with this person's got to ask that person who's got to pull the file, who now gets it over. Perhaps it has to be scanned. So my recommendation is going to be patience. And as far as your record delivery, we really believe it's in best practices to provide everything electronically to our clients at this point. We don't know how long the virus can last on surfaces. When we receive records in from a client or a custodian that is paper, obviously there's got to be concern for our employees as well. So we have already set up protocols with all of the custodians to see if we could get downloads from them, if we could do secure emails. We're very fortunate because we have a very large IT department and we're very sophisticated, but not all copy services have that. So please realize things are going to take more time for some companies than others. Wendy, do we have any questions at this time for me?
Actually, we do have one question for you. You said that the best way to get the records is to order them online. So how do we learn how to do that? Because usually somebody comes into our office and they train us on how to use someone's order form, and they can't come to our offices at this time.
In our case, and in most companies' cases, you need to go online and ask for a username and password if you don't have that. And you can email myself or any of your representatives from MacroPro. We have a link that actually our lovely Wendy here has put together a training video so that you can look at it. It's a short, very quick 5-10 minute little video that shows you how to go online and how to order records, and also too, there are lots of free tools that are available to you, and she can send you a link to that video as well. So if you don't know how to do it, that's not a problem. We can walk you through it on the telephone, or we can show you and share with you that link. Well, I am now going.
I do have one more quick question.
Yes.
So somebody asked, I understand that HIPAA will not apply for COVID-19 investigations and records. So I guess it's for you and then for Chris. But
okay, I really think would be more me and Chad. So we are still adhering to HIPAA. I think the relaxing of HIPAA was not for us investigators. It was really more for telemedicine and for the doctors that need to have access to records more quickly than what they would have been able to have immediately. And I think that all of the facilities are now able to do secure emails and be able to log into the systems faster. So I really think the relaxing of that really isn't affecting most of us that are providing records and information regarding a claim. Chad, would you like to chime in on that question?
No, I would just mirror what you said. The changes weren't intended for us. They were intended for delivery and exchange.
All right. Well, we are coming close to the end of our hour. I just want to invite all of you that if you should have any other questions regarding COVID, of course, the DIR is always going to be updating their websites, and you can check them. Real quickly, I'd like to get a recommendation from each of our experts. So, Chad, do you have any recommendations you'd like to give to the claims community?
Sure, and this goes back to the last question we left unaddressed. Now's a good time to try to settle your cases. The applicants' attorneys are not spending 6 to 8 hours at the board. They're working remotely, and they're able to get to files and look to value them where they were unable to do so before. Their business model just didn't support it. In cases where you have representation, when you have an applicant's attorney, the board is not going to get in the way of a reasonable settlement. If the applicant's attorney has put their mind to valuing it, the defendant has put their mind to valuing it, and they come to an agreement that appears reasonable. 99% of the time, a judge is not going to get in the way of that. And because the applicant's attorneys are not in court settling cases, they have cash flow restraints. So they're actively encouraging defense attorneys to talk about cases. Give me a call, let's try to settle something informally. Injured workers, same thing. Anytime there's a cash flow impact on injured workers, there's a need for settlement and a desire for settlement. The other thing injured workers have right now is they may not want to go to the doctor anymore. They may not want to participate in depositions and evaluations and go to court hearings because of fear, and they may prefer just to go ahead and settle their cases. So you be fair. As long as you're fair and as long as you're dealing with in represented cases, the courts are approving settlements.
Great, thank you. Ashton, last word from you.
Probably for me, I think the biggest thing is probably safety. There are QMEs out there doing evaluations currently. I would ask all of you to help us and encourage your applicants to communicate with us if they possibly have been infected or if they've been sick, because we don't want sick people going out and getting other people sick. So we want to still be able to do our job and be able to provide evaluations and without anyone getting infected. So if you all can help us out in screening, that would be great. So that's about what I have there.
Great, thank you. Chris?
I was just reminded by one of my colleagues in the industry that during a time of lockdown, every day is a Saturday. I think you're all probably finding things to do around the house to keep your mind going and keep yourself busy. They just told me they went out over a few days ago and got 3 days surveillance of somebody, working outside, drinking beer, doing yard work. So again, companies are working. Now is the opportunity to catch them at home. They're not going anywhere. But my recommendation would be, hook up your smaller PI firms, help them out, help out the small local vendor. I know you have panels you have to go off of, but these guys, they're out there still working, still doing their thing, paying the bills. If you have an opportunity, try them out, and you might like what you find. They're willing to work with you. So be safe.
Thank you. And I'm going to just remind everybody to please be patient with your document retrieval company. They are going to do the best that they can for you. Lastly, if you need to get records nationwide, a lot of places are not affected by the coronavirus like we are in California, New York, and some of the other major cities. So by all means, make sure you try to get those records, and there's somebody out there that can take care of that for you as well. And I wanted to give you a little bit of food for thought. I did a presentation for Work Comp Central, and it was on obstacles versus accomplishments. This is a really, really tough time for all of us. And this video here just kind of talks about how we can't let something like this obstacle keep us from our accomplishments. We can accomplish so much together. And in the workers' comp community, we are here to serve our injured workers and make them as whole as possible. So I certainly hope that all of you guys reach deep and know that this will be over soon, and we will be able to visit with each other soon too. So with that, I would like to say that we are finished with our presentation. I'd like to thank all of you for attending. There will be a certificate that will be emailed to all of those of you for CEU credits. If you have any questions, you certainly can reply to your invite. I believe my information's on that, and I can shoot questions to any of your experts. The PDF of this particular presentation is attached to this webinar, so you may download that. All of our experts' information is listed. It was on page 3, so you can reach out to them directly as well. Each of our experts provided some type of handout, so I would urge you to download that as well so that you have it. And with that, I wish you all a good day. I pray that all your families are safe and virus-free. Thank you, panelists, and thank you, Wendy.
Thanks, Diane.